Every day in the USA, people find themselves in court.
We are here in the case of Vicky Kirkstra versus Progressive Marathon Insurance Company, case number 25-21194-CK. This hearing is being recorded on Zoom and live streamed on YouTube.
And we are here today on motions from the defendant to compel discovery and also to deem requests to admitted. So, Mr. Johnson, would you place your appearance on the record, please?
I will, Your Honor. If it pleases the court, Robert Johnson on behalf of Defendant Progressive, P42458.
Very good, thank you. And Ms. Kirkstra, you are here representing yourself, that is pro se. These are Mr. Johnson's motions. I did not receive a written response from you, Ms. Kirkstra. So I guess in his initial matter, what's your stance on whether or not I should grant these motions at this time?
I did file several documents into the e-filing system, like on Monday.
Were they titled a response to this, or were they
Yes.
responses to the, were they responses to Mr. Johnson's motion that he's arguing today, or were they responses to the underlying information that
No,
he's
they
looking
were
for?
responses to his motion.
Okay, all right. And I did not pull those up in the e-filing system, and I don't know exactly why. I'm still, I have to admit, I am still getting used to that. Normally, we have the somewhat inefficient system here of also filing a judge's copy, which I did get from Mr. Johnson in this matter. Why don't you summarize your arguments for me, Ms. Kirkstra?
Well, the documents that I uploaded showed that there were times at the beginning, Mr. Johnson's associate had emailed me and asked for an extra 2 weeks to provide the answers that to the interrogatories that I had sent. And I gave them additional time. As well, I also I did send supplemental responses, and I had all those exhibits in my filing. We have had communication via email. I offered to meet and confer. He did not accept that offer. I did serve additional requests regarding payment and lien holder documentation that I still have not gotten. That's
Well,
quite late.
those are your request to him, and I guess the key things today are, well, first, these requests for admission, if I deem those admitted today, is your argument that, are you in agreement that you didn't file responses at all to the request for, or the only response I have is Mr. Johnson indicated that you did respond to request to admit number one. Says that admit that the insurance policy attached as Exhibit 1 is the policy that was in effect on October 9th, 2024. And your response was, plaintiff admits that the insurance policy attached as Exhibit 1 appears to be the policy in effect on October 9th, 2024. And you say subject to confirmation by a defendant, which maintains the official policy records. That would be an admission to that. And it appears that on the other request for admit, either you didn't answer the same questions, and I guess let's take that first. Are you going to stand on those answers at this point, or did you supplement them?
No, I did supplement them, and I also, yes, and Mr. Johnson got all those supplementations. I didn't realize I was supposed to send them to the court too. But I did supplement all of those of his requests.
Yeah, well, and that's one of the difficulties in, of course, doing it the way you're doing it, representing yourself, is that, well, technically we don't send all the discovery documents to the court until there's a dispute about it, which we're here for today, and then I need all the discovery documents at issue so I can analyze what's going on. All right, well, let me take these one at a time. What's your current argument on the requests for admission, Mr. Johnson? I take it that I mean, obviously, a supplemental answer is probably late at this point. Is it still a situation where I just simply need to deem those 1 through 4 admitted?
Yeah, if I may, Your Honor, and I think, and normally I don't, when I do motions to compel or motions for more specific information relative to discovery, I don't go into a lot of background relative to the case. But I think for this particular motion, I think context is needed, and so background information is necessary for me to discuss, so that you then can appreciate the discovery requests that we've made and the responses that I think are insufficient or lacking or just not provided. So if I may, um, Ms. Kirkstra was a named insured of Progressive on October 9, 2024 for a 2019 Kia vehicle. That vehicle was being driven by Ms. Kirkstra and was involved in a motor vehicle accident and sustained damage to the vehicle. Progressive deemed the damage to be resulting in a total loss of the vehicle. My client issued a payment to the Hyundai leasing company because they were the listed title owner of the vehicle with the Michigan Secretary of State, and they had a lien because of a lease of that vehicle. Ms. Kirkstra was married to an individual by the name of York Lynch. Um, and it's important to understand that because York Lynch is the individual that leased the vehicle on January 26, 2019 from the Hyundai leasing company. He did it through the Sealy Hyundai Kia dealership down in Kalamazoo.
And
On
I know
September,
I read somewhere in perusing these answers last night that she denies that she was married to him. It really isn't a substantive matter in this, other than that's how,
no,
that
it,
York Lynch's name even comes up, is that, arguably he's the husband, but even if he's not the husband, there's no argument here. Miss Kirkster appears to have had permission to drive this vehicle one way or another when she was involved in this accident. But the fact is that York Lynch is the lessee on the documents.
right, but if I may, though, it does become relevant regarding the marriage issue. Uh,
Okay.
Mr. Lynch filed for divorce in Kent County Circuit Court. The case was assigned to the Honorable Patricia Gardner. A non-jury trial occurred with regards to that divorce on September 25 of 2020. A judgment of divorce was entered on November 6, 2020. In the answer that Ms. Kirkstrip provided to the divorce complaint, she admitted that she was married to York Lynch, married in 2017 in Hudsonville, Michigan. That's important because she later, in an answer to interrogatory, said she's not married, which of course is contrary to the judgment records. But more importantly, uh, uh, Mr. Lynch filed a motion before Judge Gardner in which he requested that this particular vehicle be returned to him because he was obligated to return the vehicle to the Hyundai leasing company. The judge issued an order ordering Ms. Kirkstra to return this vehicle, and she had to do so by June 15, 2022. So 3 years prior to this, I'm sorry, 2 years prior to this loss, she was under court order to return the vehicle. She wasn't even supposed to be in possession of this vehicle because it wasn't her vehicle. It was a lease vehicle in which the lease required it to be returned. She she disobeyed that court order. All right. And so that becomes important with regards to discovery responses. After she filed her lawsuit, in her lawsuit, she identifies the vehicle as a 2019 Hyundai, I'm sorry, 2019 Kia. She puts a VIN number in the complaint. That becomes important in a minute too. She then filed initial disclosures in February of 2026. She produced no records with her initial disclosures, contrary to the Michigan court rules requiring her to produce records in support of her claim. I then submitted interrogatories, request to produce, and request for admissions on March 19, 2026. And the questions are very specific. They're less than the number allowed under the Michigan court rules. The request to produce were very specific. And the request to admit, I wouldn't describe as being overwhelming. There was just 4 of them. Um, she did not respond to those within the 28-day period. She didn't ask for an extension during the 28 period. She did file responses on April 21, 2026. and that's the subject of this motion. First, with regards to the request to produce, she produced no records, zero. What she said in response was, I will produce records. Well, that's not how it works. She's required to produce the records that she has in support of her allegations, and more specifically, produce the records that I asked for. And she didn't. And she didn't supplement those answers to say, oh, here they are. She hasn't sent me an email with any of the records that purportedly support her claim. So as of today, now yet, almost a month after she filed her answers, I still don't have any records. And why this is important is that her deposition is scheduled for next Wednesday, May 20th. And the deposition was pushed back to that date to accommodate Ms. Kirkstra so that she could produce all this information prior to her deposition, because obviously that would streamline the deposition. It would help reduce the number of questions that would be asked at her deposition. We could use the records, for example, as exhibits in the deposition to help the court maybe later understand when we file certain motions. So she hasn't done that. With regards to the request for admissions, the answers either have to be admit, deny, or she can neither admit nor deny and explain why she can't admit or deny. But she gives equivocal answers. Like, for example, the court already read the one answer where we actually gave her a copy of the policy, attached it as an exhibit, referenced that as exhibit, and asked her to admit that that, in fact, is the policy. And then she qualifies the answer as such, as if, well, if it's subject to law. And that wasn't what the request to admit simply asked. Just asked her, is this the policy? So she could either admit it, that is in fact the policy, and she's the policy holder. She would have a possession of her policy, or more importantly, she could access the policy from her agent. She has a duty under the discovery rules to obtain that information. She's provided no explanation as to why she couldn't do that. With regards to interrogatories, if you were to go through each interrogatory, first thing you would recognize is she changed the questions. Under the court rules, she has to restate the question and then cite and then give her answer. When she types the question, she typed the questions differently than how my questions read. That's important because it changes the context for what I'm asking for. But then when you look at her answers, she doesn't even respond to them fully. As an example, Interrogatory 2 asked her to identify the policy number of the policy that she's claiming was breached by my client. She doesn't identify the policy number. She has access to that information. She claims that she's the policyholder. She should identify the policy number. Why is that important? So that I can make sure it matches up with the policy that we're showing as the policy to make sure we're talking about the same policy number. Interrogatory 3 asks her to identify the VIN number of the vehicle that is in dispute. She says she doesn't know the VIN number in response. That's either patently false answer, because she's already put a VIN number in the complaint. So that the discovery request is important because she has to answer that question so that when I ask questions at deposition, I know I'm talking about the same vehicle. She has access to that information. She didn't do that. She says that in response to number 4, that she doesn't have documents relating to her what she claims is her ownership interest in the vehicle. She has access to the Michigan Secretary of State. She could FOIA their records. She could go down to them. She can go online and get the information. And if she would have done so, she would have discovered the same thing we discovered. The only title to this vehicle that's ever existed is the title that the Hyundai leasing company has on the vehicle. So she should be able to admit that she's not the title owner of the vehicle. With regard to number 6, the answer that she provides is patently false when she says she's not aware of a lease or lien holder or title owner of the vehicle. She's certainly aware. She was under court order to return the vehicle so the vehicle could be returned to the leasing company. She clearly was aware. So when she answers, she doesn't know that there's a lease or title to the vehicle. It's just a false answer. And number 7 is also a false answer for the same reason. She was ordered to return the vehicle. She knows who the owner of the vehicle is. Number 8, she doesn't answer the interrogatory. Number 9, she doesn't explain her answer. She makes a contention, but she provides no factual basis for her contention, which she's required to do. In fact, my question asked her to list the facts, and she doesn't list any facts. Number 10, she doesn't provide a full answer. Number 11, she's asked what she thinks the value of the vehicle is. for purposes of this case, and she doesn't provide her value. She just says she just disputes how Progressive valued the vehicle. Well, that becomes important because if she thinks the value is different, she has to provide the facts for that, identify the witnesses that can support that. She doesn't provide any of that information. Number 12, she doesn't respond fully. Number 13, she doesn't identify any specifics in regards to her contention. In 14, 15, 18, and 19, the same thing. She provides no explanation for her contention. She just makes contentions. And as I pointed out before, she's provided absolutely no records, none, in response to the request to produce. And she certainly has records in her possession. Or at the minimum, she should respond by saying, I don't have any records. Right? She has a duty under the discovery rule, and that's why you have 28 days to make inquiry to obtain the records so that they can be produced, so that I can compare those records to records that I have to see if they are the same, for example, if they're different, why they're different, so that I can analyze it. And more importantly, I can use those records during the course of the deposition of either this party or of other witnesses. And she hasn't given me that availability. So that's why I'm asking the court, to deem all of her requests for admissions as admissions, not equivocal, but unequivocal. These are admissions. And she's provided, she said she provided supplemental responses. I admit she did. This is what she did. Other than she removed the word plaintiff from preceding the word admitted, she bold printed the answers. Otherwise, the answer is the same. She didn't change the answers. She just bold printed them as if that's somehow to distinguish that's different than the previous answer. So they're still equivocal answers. They should be unequivocal. And so I'm asking the court to order her or to deem those admitted. With regards to my motion to compel, I know that I could ask the court to dismiss Ms. Kirkstra's litigation for violation of the discovery rules. I've already had to file one motion relative to discovery, which the court has already ordered her to comply with the discovery rules. But I know realistically that that's a harsh request to make, and I know that the courts are reluctant to dismiss cases for discovery violations. So I'm not asking the court at this time to dismiss, but what I am asking the court to do is order Ms. Kirkstra to respond to the interrogatories fully and completely, and to do so prior to the start of her deposition on May 20th. 2, I'd ask the court to order her to produce all records that I've requested and records that support her allegations against my client, and to do so on or before the start of her deposition on May 20th. 3, I'd ask that the court order Ms. Kirkstra to pay my client for the fees that they're incurring for my time of having to file this motion, to attend this hearing. And I think a fair amount is $500. And I'd ask that the court order her to pay that $500 on or before the start of her deposition on May 20th. And then 4, I'd ask that the court order her to appear for the deposition on May 20th as properly noticed. And that in the event that she doesn't comply with the court's orders that I'm asking that the court order, I'd ask that the court then dismiss this case if she doesn't comply with those court orders. Thank you.
All right, very good. And you said I've already issued a previous discovery order. Was it on the same material, Mrs. Johnson, or was it on a different requests?
It was on regards to initial disclosures and her duty to respond in compliance with the Michigan court rules. She wasn't following the court rules as far as where she was sending things to, not giving me copies.
And that's at least you're getting the documents now, or they're getting filed properly. So she's not violating that. She still hasn't made the initial disclosures per your argument today. And on top of it, you're asking for another order regarding this discovery, the responses that those be provided. And you've got a deposition date. It sounds like next 20th is Wednesday, maybe. So
That's correct.
coming right up. Okay. All right, Ms. Kirkstra, your response?
I'm going to say there is there's so much there. I have responded. I've asked for specifics for things that he wanted. This is the first that I heard of anything specific that he wanted from me. And he has.
Well, when he's requesting those documents, I mean, it doesn't take, at the end of the day, if you've got documents, policies, any ownership, indications regarding this vehicle, repair bills, things of that nature that would point to things like that are in your control. Those just simply have to be sent to Mr. Johnson. You can't endlessly ask him, oh, well, clarify or narrow down or whatever else your request here. At the end of the day, if you're not making a legal objection to producing them, then you just simply need to send them to him. Do you have documents in your possession that have not been sent to Mr. Johnson, or is it a case where you don't have anything more?
No, like the policy, I did it all online, so I did not have an agent I could talk to. And once this claim was filed, the policy was done, so I could not even access my online account.
So
And
that's a fair answer to say you don't have a different policy, in other words, in your
Right.
possession.
Right, so that's just an example. I did not have the policy number. So and somebody did send me from Progressive a copy of the policy, but I don't believe it had the number on there. But I'm happy to go through, and I've been trying to write notes here what he's looking for. And like I said earlier, I still do not have answers to things that I requested from him, and I did give them. Like I said, his attorney or his associate or assistant asked for an extra 2 weeks, and then he also said that I did not send him the stuff, and he actually sent me a letter that he was taking over as counsel that you had not even signed yet. And I conferred with the court clerk to make sure that that was right. And she said, yes, that you had not even signed it yet, when he sent me something in the mail that said he was taking over. So
well,
as
the
soon as
thing
I
is
came-
this, and I don't want to interrupt you much. I mean, you have the same legal mechanism that's available to Mr. Johnson here, in that if you think he's not timely responding to your request, sir, you can file a similar motion to what he's filed. But the fact is he's filed it. It is before the court now, and I've got to make an order. And when I issue that order, and I put deadlines in there and things like that, Ms. Kirkstra, you have to know if Mr. Johnson argues, a couple of weeks down the road that you didn't follow that, then one of the options I have to consider is the dismissal of the entirety of your claim, because it's non-responsive. So, and part of it is, and I would encourage, and Mr. Johnson's heard this lecture before from me, that, I don't view the discovery process and the litigation process as game playing. It's an exchange of information. At the end of the day, if you have information, rather than, trying to point out, a way you think the other side should have asked for it better, or you don't think it's necessary for them. If you have information in your possession, you should send it to them. It's that simple, so that, and his motive there, might that information be used against you, somewhat like in a criminal case? Of course it might, I guess. And the best example would be at a deposition. Well, if he walks in there with the insurance policy that you sent him, he might ask you a question like, is this the only copy you've ever received? And you'd say, yeah, as far as I know, that's the insurance policy. That's what Progressive sent me. And you're stuck with that policy terms. Then you can't, necessarily go back and say, well, no, I think there was another policy, or a different policy that pre-existed. But, that's the end of the day. And what we're doing here is it's a fact discovery process, and that we're trying to figure out, what documents are and information are in the possession of the other party. So I am going to order you to produce what you have, because you have said, well, Progressive sent me a policy. Well, if they sent you one along the way here, in your efforts to get a copy of it or whatever, and you've got a copy, be it electronic or a paper copy, you need to provide that to Mr. Johnson. That's all there is to it. So, because your deposition's coming up, I'm going to have you do it by close of business on Monday, so he can examine those documents at least during the day on Tuesday, and then he's ready to take your deposition on Wednesday of next week, at which you'll be under oath and, of course, required to answer those questions. So, I'll order that the documents and any supplemental written answers to his interrogatories. I would encourage you at this point, because we're late in the game, focus on getting him those documents. He'll likely ask you some of the questions that are in the interrogatories, again, and it's not the most efficient way to do this, but it's happened before, where you might be asked those same questions during your deposition, and again, you're under oath and you're obligated to answer because of the situation in the deposition. You'll not have an attorney there to object to, Mr. Johnson, the form of his questions. And frankly, because it's discovery, he's got a lot of leeway to ask you a lot of questions about stuff that you might not think is related, the marriage, divorce, etc. Mr. Johnson's pointing out to me, well, he believes it's very closely related to the coverage and stuff like this. You might disagree with him, but at that deposition, you're obligated to answer the question and to answer it honestly, or again, you can expose yourself to sanctions in this process. So, and I'm going to decline to enter those sanctions at this time. However, I will expect, like I say, disclosure of all documents in your possession that are responsive to his request for production no later than 5 p.m. Monday. What I would advise you to do is, if you've got a home file that's got, all the stuff that you saved here, that may go back a ways or whatever, hand it over to Mr. Johnson, even if you're not sure it's relevant or whatever. And he can do with it what he thinks is, the appropriate. And the most important thing he's going to do is review those documents and then use them to formulate questions to you under oath when you give your deposition in this case. I'll also ask you to supplement any interrogatory answers that you have more information, but I'd like you to focus on the documents, just given the timing here. What I'll do is I'll say supplemental documents no later than 5 p.m. Monday, interrogatory answers no later than 5 p.m. Tuesday. That way, Mr. Johnson can look at those in the evening and modify his questions and things. But I think the documents are far and away the most important part of this. And they have to be, somehow delivered to his office. And I don't know if you've got them electronically, I'm sure he can receive them email wise. Otherwise, you may have to hand deliver them to Mr. Johnson's office, or utilize an overnight delivery service or something of that nature over the weekend to get them there by 5 p.m. Monday. With regard to those 4 requests for admission, because of the answers, those being equivocal and not in compliance with the court rule, I don't have any choice at this point but to deem those admitted. There are only 4 of them. They're just kind of basic, was this the insurance policy or not, type questions. And, it appears that, given the responses that you gave, that I have no choice at this point but to deem those admitted. So
Did you?
those are just the 4 requests for admission, not the other ones. And there's nothing further you need to do with those. If you think you need to modify your responses after your deposition and those things, you can file them. There is a way to go about that and to file amended answers and things like that. But for the moment, they'll be deemed admitted. And, that has what Mr. Johnson's doing here is all lawyers would do, is he's trying to build a case where he can then ask me to dismiss the case without going to trial based on those answers and the policy documents, that you're going to provide him and that he's already got. And if, it's okay to say, I don't have those, or the defendant's in the possession of those documents, that's an acceptable answer. But if you've got something, you've got to produce it. Don't just say, well, you've got this too, you're the insurance company, because he wants, your best response as to, here's the policy document I'm relying on, I'm reading when I come to my conclusions about the case. So don't always rely on him. If there are documents that you don't have, just say, I don't have anything. I've got 0 at that, regarding this particular request that you've made. So, and that then is helpful, because then Mr. Johnson knows that you're not going to, a week after the deposition's taken, you're not going to come across and say, well, I you now have this document and here's, additional information or supplemental information. It's trying to do this in an efficient way, so he has to take your deposition one time, not a bunch of times, because documents keep kind of dribbling out in the case. So do you understand what's required there, Ms. Kirkstra?
By the end of the day on Tuesday, the interrogatories, end of day Monday, any documents that I have.
Yep. And
And
then sit for your deposition on Tuesday, and you're going to have to answer those questions honestly because you're going to be under oath and, of course, subject to perjury. The court reporter will swear you in before you take the deposition. So, what we're trying to do is keep the case moving, get that information exchanged, and then we determine, if there's enough of a case here to put a question in front of a jury. I don't know, did you file a jury demand with your lawsuit, Ms. Kirkstra, or is it going to be in front of me?
I think it's just in front of you.
No,
Okay.
it's, I believe that we
Or
filed
maybe you
a
filed a
jury
jury
demand.
demand. Okay. All right. Well, so there is a jury demand, and that's another thing. Should this case progress past the motion stage, a motion is where I decide that, if Mr. Johnson was to file it to dismiss the case, then what he is saying is, Judge, look at this enormous pile of evidence I have that says everything I'm arguing is correct. Ms. Kirkstra doesn't have, enough evidence, that would make a difference if we put it in front of a jury. You can just decide this one. That's the motion, he's working towards down the road here. And then ultimately, if I deny that motion, then the case does go in front of a jury because Mr. Johnson's requested it. And if I grant that motion, then the case ends at that point because, I've decided legally there just isn't any more question to be decided by a jury in the matter. So, that's kind of where we are in the process. But what we're doing now and what Mr. Johnson's doing is, he's just simply nailing down, these are the final and for this case, end all be all responses to the questions and requests for productions of documents. So, it is advocacy, but it's nothing nefarious or underhanded. It's just the way basically every insurance type, case like this would work in this court. So anything, Mr. Johnson, you can send me an order, although it's probably going to arrive, after the fact here by the time I sign it and everything and get it back to you, granting the motion. I am not going to grant, like I said, I'm going to hold off on granting that $500 in costs. I will caution you, Ms. Kirkstra, that, it's a totally legitimate request by Mr. Johnson because he's arguing essentially and has to justify, when he goes back and reports to his client that, we spent this time, but this wishy-washy judge wouldn't grant me costs on this particular motion. I try to, this discovery in a normal case is expected to happen without a whole lot of motions like this and the court's involvement. It should just kind of happen. And when every time he has to come in court and file a motion and do what he did to get this hearing today, he does expend his client's money and his client's going to expect him to ask me to recover that. I'm not going to do it now because granted, I'm going to hold it under advisement because of your status as an unrepresented plaintiff in the matter. You don't have counsel, and the court rules allow me to give you some leeway, but I'm here to warn you. I'm not going to tolerate any game playing with answers or production of documents going forward. I will impose sanctions, and then you're going to run into a situation, where if I impose those sanctions, then it becomes not I get money if I win, but you just simply have to pay them as part of the litigation, or Mr. Johnson will just lump it in there and say, that's another reason, Judge, you should dismiss this case. So the stakes are high, and particularly for you, Ms. Kirkstra, as an unrepresented individual, it's a like navigating, in some ways, trying to go through a new city without any kind of map or anything. You're just kind of guessing at the next turn. And like I say, I'm allowed to give you some leeway, but I also need to follow, the case law is very clear that I need to follow the court rules and hold you to the same standard I would hold, an attorney to. So I'm trying to balance those two issues in this ruling today, but I do want to let you know, Ms. Kirkstra, that indulgence is not, going to be the kind of thing that, protects you forever. In other words, at some point I got to enforce the rules. So.
And did you say I need to file a motion to get him to answer?
Yeah, if you want him to answer, if you think his answers are deficient, you can file in a sense, the same motion that he filed here, as, it's the motion to compel, and it says, Judge, and you would attach his answers and an explanation of why they are not responsive to the question that you answered. And then you can also, then you contact Wendy and get a date on a Friday, and I'll hear your motion as well.
Right. Your Honor, if I could, just for clarification, first responding, I just want to make sure there's a record's clear by my silence. I'm somehow agreeing that we've not complied with her discovery request. We've answered all of her
No,
interrogatories.
I understand.
I know, but
Mr.
I just want to make sure.
That's not in front of me right now, so
Okay.
I'm not making any ruling on
Okay.
your compliance or non-compliance, and I would expect it. I should add, Ms. Kirkstra, that, and I did find your response actually in the stack of documents. I had just buried it in the, because I have so many documents involving this case, but I did find your response, Ms. Kirkstra, and if you file that, of course, Mr. Johnson can file a response as to why his responses are adequate. So, but I'm not ruling on that because it's not in front of me today. And as I was going to say, the last step would be, you're right, you'd contact Wendy and get a date and time to have the motion heard before the court. And that's assuming you and Mr. Johnson can't work it out, because sometimes in conversing back and forth, if it's a non-controversial document or something of that nature, or you can just simply, he can send you a copy of it, and then that's suffices. So,
right. For clarification on the order, then I'm going to submit to the court today for entry granting defendant's motion to deem the request for admissions as admitted, and then I will submit a separate order to the court for entry today, a motion granting the defendant's motion to compel, in which the plaintiff has until 5 p.m. on May 18, 2026 to produce all documents and records that she has in her possession that are responsive to our request, that the plaintiff has until 5 p.m. on May 19, 2026, in which to produce supplemental answers to our interrogatories. In that third, I didn't hear the court indicate that she is ordered to appear for her deposition on May 20th as ordered. I think it's sort of implied in the timelines you've given. And so I would indicate that she is to appear for a deposition as noticed on May 20th. And then the final is that pursuant to the court's ruling that defendant's motion for $500 in sanctions is denied, but it's denied without prejudice. Meaning that if I believe that there's further discovery requests, I have the right to re-ask for financial sanctions.
That sounds all accurate to me. Do you agree, Ms. Kirkstra?
I didn't remember that it was without prejudice, but okay, or with or
Yeah,
without.
well, that's right. That means simply that he can ask for it again
Okay.
down the road.
So does he want me to go through all the pages of the interrogatories, or does he have specific things? He mentioned some things today.
No, he wants you to go through them all and answer. And an important thing here is that not if you're trying to reformulate his question, and I know a part of it might just be you're trying to get a neat copy or a typed copy out there of his question, but in retyping it, obviously you got to do it word for word, and there might be little subparts of the question or whatever that you did not respond to. You can reference the motion he filed today, and it's if you don't have information or you can't remember information in regard to the interrogatories, it is okay to say, I don't recall this date or time at this time. That's an acceptable answer. And then, as I said, and then that notifies Mr. Johnson that, he can follow up with it again at the deposition or cross-reference it against the documents you provided. Like I said, it's an attempt to get as much information as possible exchanged between the parties, without having to do a hearing like this. So.
Okay.
All right. I'll get that submitted for the court's entry today, Your Honor.
Thank you.
Very good. And you're planning on attending that dep? We're not going to be back here on a motion to compel your attendance at the deposition, Ms. Kirkstra?
No, it's going to be really tough for me to rewrite all those interrogatories and answers and everything and be there.
Well, here's my one little tidbit is if you can even, I've seen individuals sometimes supplement with handwritten answers. as long as you're doing that and signing them at the end, because you are bound by the answers, you
Yeah.
once you do them and sign them, they become your answers. But, there's no hard and fast rule that those must be typed out. I would hold a lawyer to that standard, but an individual trying to do a case like this, you again get some leeway. If the way you can do it is give yourself a little bit of space and write an answer, but just the most important thing being is it's responsive to Mr. Johnson's question and subparts of that question entirely, not
Right.
trying to be a shortcut. So,
Your Honor, I'll make this even easier for Ms. Kirkstra. I will send over to her our interrogatories and our request to produce in Word format so that she'll have it electronically, and then she can just simply in that Word format document type in her
type
answers,
in
and then
answers.
she
Can
can
you deal
manipulate
with
the
the
spacing she
Microsoft
needs.
Word document, Ms. Kirkstra?
Pardon me?
Can you deal with the Microsoft Word document with
I
your
can.
computing? Okay, all right. Well, then Mr. Johnson will email that to, at least give you a running start on getting those answers in.
Okay, thank you.
All right.
Very good. Thank you both.
Thanks,
Have a good
everyone.
weekend.
All right, take care.
This is the people of the state of Michigan versus Daniel Vaughn, case numbers 26-00971-FH and 25-10345-FH. And this hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court today on motion by Mr. Vaughn to counsel, Mr. Gears, requesting a modification of bond and release decision at this time. So at this time, I'd invite counsel to place your appearances on the record.
Tiffany Burks on behalf of the people.
Frank Gears on behalf of Mr. Vaughn.
All right. And Mr. Gears, this is your motion. I do have, it looks like I have Mr. Vaughn on two separate cases, although your motion only comes up in the 25 case. I got a 25 and a 26 case. And it's a scenario where he just simply, I revoked bond because of a positive drug test. Was that the situation here?
That and a tether and a curfew violation, Your Honor. Yes.
Okay. All right.
And I believe he has 3 cases up with you now. For whatever reason, my colleague Jason Seifert has 2 of the most recent ones. I have the oldest case and the less significant one. That happened first, though.
I see. And I've already set bond on the other cases. I just revoked bond on the oldest.
That's
when the
correct.
new stuff came up. Okay. And so I just need to set a bond here, and then we'll deal with the bond. I take it. Do you know the bond terms on the other cases?
I believe one is a $2,000 10% bond, and the other one is a $500 cash surety. My understanding, he has posted both of those before they came up to circuit court. And then yes. So
All right.
$2,500 altogether, I guess.
Got it. And so obviously, because the charge, and those were mandatory non-PR bonds because he was on bond already.
Right.
In that case, but this case, I don't have that restriction necessarily. Ms. Burks, what's the people's position on bond on this matter?
Your Honor, the people have no position.
Okay. All right. Well, I do think he is entitled to a bond. You think he can manage the tether this time, Mr. Gears?
I believe he can. I know his rationale for this current incident was that his niece had something to do with it. I think he has resolved that and would not be in contact with her, so hopefully that would not be an excuse or a reason this time. I would also say I received something from the MAP program of Mr. Anthony Sledge indicating that he has been fully engaged in that process. And if he were to be able to post bond, he would be looking into inpatient treatment. in the interim for his substance abuse.
Okay, all right. Well, certainly in favor of that. Yeah, just thinking out loud, these are all substance abuse charges. Is that accurate, Mr. Gears?
That's the underlying problem here for sure, and over the majority of his criminal history, going back to, I believe, the 80s. So
Yeah,
it's a
no,
long-term
right.
problem.
Yep, and I see it manifests kind of as retail fraud and well, and troubling here. I mean, he does have as you're doubtless painfully aware, a huge record. None of it, at least in recent history here, appearing to be any violent offenses. A combination of theft and drug. Unfortunate story. So. I will then set bond in the amount of personal recognizance bond in this case for $5,000, provided he's fitted with the GPS tether. Before release, abides by the tether program, avoids contact with the niece who has been problematic. Do you know what her name is by chance, Mr. Gears?
I don't, Your Honor, no.
All
I don't
right.
have that in front of me.
If you can find it and stick it in the order for me,
Sure.
so we can kind of memorialize that with no contact with her, and that he continues receiving treatment through medication-assisted treatment. I will set that as bond terms in the current case.
Now, regarding the tether, Your Honor, I know we had a motion a month or two ago on that regarding the waiving of the fees. It was determined favorably, I guess, that because he is on some sort of assistance, that would excuse him from those fees. Would that remain accurate?
If it worked before, I'm willing to do it again. Although, my understanding, because it's a bond tether, they do it through house arrest services.
Okay.
I don't know who picks up the fee, if it's the county or if it's court services, if they have a means of paying for that for people that are qualified for disability, I'm in favor of it. But if it can't, if that's not available for him, then he's going to have to pay it. So
Okay. Sounds good.
All right, and you'll send me an order, Mr. Gears?
I will. We'll get that out this morning, hopefully.
Very good. Thank you.
Thank you. Have a good weekend, everyone.
You too. Judge, was that just in the 25 case?
Just in the 25, yes, right.
Okay. Okay.
Because the other ones he's got bond, I think, set already.
I believe so, yes.
Yeah, I just revoked him because of the various issues.
Okay.
All right. Thanks.
You kept the car you didn't own, and now your secret scheme is known. You hid the papers from the court. Now time is running very short. The judge demands the